Hi. The Supreme Court in De Leon versus Duterte dismissed a petition that would have compelled the president to release information illustrating or explaining the state of his health. I think the Supreme Court was wrong. Why are we concerned with the president's health? We are concerned with the president's health because the president himself makes it an issue. Here at the end of 2019, the president talks about how he's not at the peak of health. So something that should concern every Filipino citizen because we want our president to be healthy. We want to be assured that the president is doing well and can actually lead the country. Still, at the end of 2019, Duterte is quoted as saying that life is taking a toll on his health. Similarly, alarming. Now, because of the pandemic, we are treated to a weekly briefing from the president on what the government is doing to address this health crisis. But in this particular briefing, one evening, the president talks about the Philippines and refers to it as this fucking country. The Philippine president said that on national television. And this is also the same briefing where the president inexplicably digresses and starts to talk about the Roman Empire and how those with birthmarks are witches and how they're burned at the stake. This is the president of the Philippines talking about burning witches at the stake in a briefing that's supposed to assure the country that the government is doing what it can about the COVID-19 pandemic. The president goes on that night to rant about so many things. No one could understand what he was talking about. It was so offbeat. It was unorganized. It was either jazz or poetry. And some netizens have reimagined that rant as poetry. But seriously, you can see why people are concerned about the president because here he talks about the bubonic plague. He talks about the Middle East, the Roman Empire. Talks about being burned at the stake on national television, live. So what happens from a legal point of view? What do we do when the president's health is in question? There are at least two constitutional provisions that come to mind. The first one is Article 7, Section 12, which states that in case of serious illness of the president, the public shall be informed of the state of his health. So it's a positive duty to inform the public of the president's state of health. And there is also a related provision in the Bill of Rights, Article 3, Section 7, that talks about the right of the people to information on matters of public concern shall be recognized, and access to official records shall be afforded the citizen. So there are at least two provisions of the Constitution that are implicated when the president's health is in question. Now, why do we have these constitutional provisions? We have written them into the Constitution to address the practices in the past. And I remember on more than one occasion, then President Marcos would disappear. No one would know where the president was. And then one day in the newspapers, the next morning, for those of you who have never seen a newspaper, this is a clipping from the Journal Herald, November 22, 1984. And that's what the president would do. He would show up holding the newspaper from the day before to assure the public that he's not dead. That reports of his death are exaggerated. I think Marcos actually quoted Twain, I think, to make light of his situation. But let's examine this. Look at the headline there on the photograph. Marcos stresses he is healthy. But let's look at this very, very short article because I think it demonstrates why we need to be assured about the president's health. So the president cannot be found. So his former information minister, Francisco Tatad, says that he had major surgery. It could have been his heart, could have been his kidneys, could have been both. I'm not sure, but I know the operation was a success. Way to assure the public about the president's health. Not what you want to hear. So the palace issues a statement saying, no, he's in seclusion because he's writing a book. The first lady says, no, he's just sick with a cold and bronchitis. And the palace issued another statement, I think earlier, saying that he would visit typhoon ravaged areas in the country. So you have four different explanations in a single news story. It's like 100 words. So there's confusion and understandably concern from the public because we need to know who's in charge of the country. In a Chicago Tribune article about the same time, October 28, 1985, they identify the illness that Marcos supposedly is suffering from, lupus, systemic lupus erythematosus. And that is how the word lupus is introduced into our vocabulary for many of us. That's the first time. Interestingly, this is a 2016 article that talks about how doctors affirmed those rumors that they treated Mr. Marcos. Marcos had in fact undergone two operations. One before Benigno Aquino Jr. was assassinated, and one after that. So at least two. And this story talks to the surgeons who performed those operations. So if you have a situation where the president's health is in question and constitutional provisions that are implicated by that situation, what do you do? Well, Attorney De Leon files a case to compel the Duterte to disclose health records, citing the constitutional provision that that I cited earlier in this presentation. What's mandamus? Well, mandamus is employed to compel the performance of a ministerial duty, not a discretionary duty. The other requirement, according to the Supreme Court, is that the petitioner should have a clear legal right to the thing demanded. I have a right to know. And there must be a duty on the part of the public official, the respondent, to perform the act that is required. What do we mean by discretionary and ministerial? Well, discretion means a power or right conferred upon them by law or acting officially under certain circumstances, uncontrolled by the judgment or conscience of others. In other words, it is up to that public official to perform that duty, and it is not to be controlled by anyone, as opposed to a purely ministerial duty where the performance of that duty is prescribed by law, without regard to the exercise of his own judgment upon the propriety or impropriety of the act done. So one is, this is another way of looking at it, if the law imposes a duty upon a public officer and gives him the right to decide how or when the duty shall be performed, such duty is discretionary. It is ministerial only when the discharge of the same requires neither the exercise of official discretion or judgment. When the official cannot say no, then it's ministerial. You do that. A discretionary, in case of a discretionary duty, the official can decide how this duty is to be performed. The right to decide. Okay. These are excerpts from the records of the Constitutional Commission. And it sheds light on what the provision means. Here, we have Commissioner Gingona suggesting, that we provide for the manner in which this right shall be enforced, and he talks about how a law should be passed to make sure the public is informed about the president's serious illness. Now, Commissioner Ople is initially, agreeable to the suggestion, so he changes the language of the proposed provision to refer, to include that phrase, as may be provided by law. Then he changes his mind right there after an expert on medical matters came around. And he said that perhaps we should just trust the office of the president to determine how this information is to be released to the public. Of course, Commissioner Gingona says, well, we just had a president who made sure that we were not informed of the state of his health. And he's right, of course, he's referring to Mr. Marcos, and the Ople's response is, well, maybe you should lead another march. I think it was trying to be funny. Okay, so the way the provision is finally worded, it's there, no law is required to be crafted by Congress. But there are references to a right to know in the same the record. And in this excerpt, we find that at any rate, the thrust of the amendment is that at least the public should be informed. And Mr. Ople himself says it is the public's right to know. There you go. There is a right. There is a right to know the president's health, and that the public should be informed. It sounds to me like the Supreme Court standards have been met, a duty and a right that is asserted by the petitioner. If we read on, the records tell us that there is some ambiguity in the word serious. No one really knows what the word means, because some members of the commission were talking about examples. And Mr. Ople says that illness is serious if it almost but not quite incapacitates the president. Almost but not quite. Could you be more vague? I doubt it. And he doesn't want to give a technical definition because he thinks some technical expertise is required for us to conclude that a person has a serious illness. What about dialysis treatment? Is that a serious illness? And Mr. Ople says yes. A systemic disease. I suppose that this could come under the class of serious illness. Mr. Suarez in the end makes a reference to future interpreters of our Constitution. So I guess they knew that in the end, the Supreme Court would have to determine what we mean by a serious illness. We also know, without having to go through all of this, that the failure of the president to reveal, to provide information about his health is not an impeachable offense. I am not inclined to say at this point that it attains to the level of a culpable violation of the Constitution, which would be a ground for impeachment. Now, what are the consequences? Well, Article 7, Section 8 of the Constitution says that case of death, permanent disability, removal from office, etc., the vice president shall become the president. Shall become the president. So if we find out that the president's serious illness actually amounts to a permanent disability, then the vice president becomes the president. What else? Well, if we look at Article 7, Section 11, there's another provision. This other provision talks about how the vice president can become acting president. The majority of the members of the cabinet think that the president is unable to discharge the powers and duties of his office, then the vice president shall act as president. And if the president refutes that assessment by the cabinet, in the end, the Congress can step in and make that determination by voting separately. Congress shall convene if it is not in session within 48 hours in accordance with its rules without need of call. There you go. So if there's a dispute, if there is a dispute between the president and his cabinet, that was even possible, then Congress will step in. By a vote of 2/3, voting separately, the president is unable to discharge the powers and functions and duties of his office, the vice president shall act as the president. Otherwise, you don't get enough votes, the president shall continue exercising the powers and duties of his office. What I'm saying is, what if the report of the president's health convinces a majority of the cabinet and ultimately members of Congress that the president is not fit to discharge the functions of his office, then this provision might come into play. So, illness by on the part of the president can trigger a variety of constitutional provisions. So, Attorney De Leon files his petition for a mandamus, and rather quickly, the court dismisses the petition with through a notice, and it's a very, very short notice from the Supreme Court. Not a decision, it's a notice. By the way, we dismiss this case. And why did the court dismiss the case? Well, they cite the provisions of the records of the Constitutional Commission that refer to the office of the president as being responsible for the manner, the appropriate means of releasing information to the public, suggesting that it's not a duty on the part of the president, that it is up to them entirely, a discretionary, rather, I'm sorry, the president, the court suggesting that this discretionary on the part of the president. What else? The court says that all the allegations by Attorney De Leon are hearsay evidence, unverified, speculations, surmises, biases, etc. Surmises. And the court concludes already by saying that, in recent months, we've seen the president holding regular cabinet meetings, without mentioning, of course, that the president goes off to rant about the Roman Empire and burning people at the stake. Because the court actually refers to the president's regular televised addresses to the nation to prove that allegations of serious illness are unsubstantiated. I don't understand it either, because that's what you're thinking. So the court's it's full of surmises and conjectures. And of course, the petition is dismissed. Now, there are two dissents in this case by Justices Leonan and Kegiwa, because they're always in dissent. And I've not really read them because I didn't want the dissents to influence my own opinion. And here, the first comment I have, of course, is, my God, you didn't even ask the respondent to answer it. You just dismissed it. And these are my other observations. Of course, there are surmises and conjectures because we're not sure about the president's health. And that's the reason why this petition was filed. So you can tell me that everything is fine, because what we're seeing, what we're hearing from the president is not assuring us that he is in fact in good health. The second observation I make here is that the court ignored all the other provisions, or rather the parts of the records of the Constitutional Commission that actually talk about the right to know the health of the president. Nothing. They don't talk about those, which I already pointed out earlier in this presentation. Just a note here, constitutional records are not as should not determine the interpretation of the Constitution. Primarily, the court looks at the text, but can refer to the records of the CONCOM to determine the intent of the framers. And as I presented, as I demonstrated earlier, the intent was to establish or create a right to know on the part of the public, insofar as the president's health is concerned. Here's another observation or comment that I made. What was ministerial, really, if you read the records of the CONCOM, what is ministerial is the manner in which the records of the president's health is to be released. That is the only thing that is ministerial here. So you can actually compel, if I was the Supreme Court, the court can actually compel the performance of that ministerial duty. Just provide for the procedure to ensure that the public can be informed about the president's health. In other words, there's no discretion there because you have to find a way to inform the public about the president's health. There, that's what I just said. Mandamus could have been issued by the Supreme Court to tell the office of the president provide for the procedure to enforce the right of the public to be informed about the president's health. Case law also tells us that the courts can issue a petition for mandamus to compel a public official to perform a discretionary duty, not how it's going to be performed. But if there is a duty and discretionary duty on the part of a public official, the courts can say, can you exercise your duty as a public official? That's it, but not to tell them how it's done because it's still discretionary. But then we have another line of cases that when there is gross abuse of discretion, manifest injustice, or palpable excess of authority, the writ of mandamus may be issued to compel precisely the exercise of such discretion. Do it when these grounds are found. So the case law on this matter is really more nuanced. You don't just dismiss a case like this, especially because it is something new in the Constitution, and it's meant to address a very, very serious problem that we faced, that we had to deal with during the Marcos years. So mandamus would have been proper under many circumstances. I can control your discretion. If there's gross abuse of discretion, manifest injustice, palpable excess of authority. So again, to be clear, what I'm saying is the office of the president is not performing a ministerial duty. And that even if there was what we're talking about here was a discretionary duty, then there are enough exceptions in case law that would have justified the Supreme Court ordering the office of the president to reveal the health records that would explain the president's health. And I think the inaction on the part of the office of the president amounts to an abuse of discretion, and therefore mandamus would have been properly issued by the Supreme Court. And in the larger scheme of things, this decision prevents us from discovering the state of the president's health, because now it all depends on whether the office of the president will release the information that we are seeking. And this is only the latest in a string of Supreme Court decisions that have rendered constitutional checks inert. You have all those cases in martial law where the Supreme Court has dismantled all the checks and balances that we have written into the Constitution. Now you have other provisions where the Supreme Court is saying you don't have a right. You did not make out a case for mandamus, and therefore you don't have a right to the information that you're seeking. These are the sources for some of the images that I use there. I make no claim to copyright here. Thank you for your attention. Good day.